An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. Youngstown Sheet and Tube Company versus Sawyer, 1952. Youngstown, known as the Steel Seizure case, is one of the Supreme Court's most important decisions concerning the separation of powers between the presidency, the Congress, and the judiciary. Critically, the entire case was resolved by the Supreme Court in less than 2 months, between April and June 1952. To understand this case, we first have to recount the history of the Korean War. From 1950 to 1953, the United States was engaged in a military conflict on the Korean Peninsula. Congress did not declare war on Korea. Instead, the United Nations Security Council authorized the conflict. The United States joined the United Nations by virtue of a treaty approved by the Senate in 1945. As a result, President Harry S. Truman's administration argued that it had the power to prosecute the conflict in Korea even in the absence of a formal declaration of war. However, a labor crisis was about to erupt on the home front. Due to a wage dispute, the United Steelworkers threatened to strike at steel mills across the country. President Truman determined that the strike would frustrate the war effort in Korea because there would not be enough steel to manufacture tanks, planes, and other munitions. On April 8, 1952, one day before the planned strike, President Truman signed Executive Order 10340. Study Guide. What is an executive order? How does it differ from a bill approved by the House and Senate the President signs into law? The executive order authorized Charles Sawyer, the Secretary of Commerce, to take possession and control of steel mills nationwide that will be affected by the strike. The plant managers were ordered to continue their functions. Study Guide. What would have happened if managers refused to comply with the executive order? President Truman sent 2 messages to Congress that notified the House and Senate about the seizure. However, the President never asked for permission or authorization. He said, "The Congress can, if it wishes, reject the course of action I have followed in this matter." During this time, Congress took no action to approve or disapprove of the executive order. One of the seized mills was the Youngstown Sheet and Tube Company in Youngstown, Ohio. Within 30 minutes of the seizure, the owner of the mill challenged the constitutionality of the executive order. On April 29th, 3 weeks after the executive order was issued, the district court halted the seizure. The following day, the Court of Appeals put the lower court ruling on hold, so long as the government immediately appealed the case to the Supreme Court. On May 2nd, attorneys for the federal government filed petitions for writs of certiorari with the Supreme Court. The following day, the Supreme Court granted those petitions. On May 12th and 13th, the Supreme Court heard oral arguments. And on June 2nd, 1952, the Supreme Court decided the case less than a month after oral arguments, and less than 2 months after the steel seizure. However, there was a cost to resolving the case so quickly. The final opinion was extremely fragmented. 6 justices voted to invalidate the steel seizure. Justice Hugo Black wrote the majority opinion. 5 other justices joined him, and each wrote a separate concurring opinion. Justices Frankfurter, Douglas, Jackson, Burton, and Clark. 3 justices voted to uphold the seizure. Chief Justice Vinson wrote the dissenting opinion, which was joined by Justices Reed and Minson. Justice Hugo Black wrote a textualist majority opinion. Looking to the text of the Constitution, he explained that the President had no power to act except in those cases expressly or implicitly authorized by the Constitution or an act of Congress. In other words, the President had no inherent or unenumerated power to seize a private company. He could only order the seizure of the mills if the Constitution expressly authorized him to do so or Congress enacted a statute that authorized him to do so. President Truman cited 3 provisions of the Constitution that gave him the power to issue the executive order. The vesting clause in Article 2, Section 1, the Commander-in-Chief clause in Article 2, Section 2, and the Take Care clause in Article 2, Section 3. Justice Black found that none of those clauses gave the President the power to seize private property on the home front. Did any act of Congress give President Truman the authority to seize the steel mills? Justice Black answered no. In fact, he explained, Congress rejected an amendment which would have authorized such governmental seizures in cases of emergency. In short, the President lacked the constitutional and statutory authority to issue the executive order. Therefore, the seizure violated the separation of powers. Justice Frankfurter wrote the first concurring opinion. He explained that the scope of presidential power cannot be limited by the text of the Constitution, such as the vesting clause in Article 2, Section 1. Rather, the meaning of the executive power can be defined by past presidential practice. Study guide: what is the relationship between the executive power and how executives have exercised their power? For example, imagine if there was a 150-year-long tradition of presidents seizing private property. What if President Washington had seized private property and Congress did not object? And President Adams did the same. So did Presidents Jefferson and Madison, and every other president leading up to President Truman's steel seizure in 1952. Justice Frankfurter explained that such a systematic, unbroken executive practice, long pursued to the knowledge of the Congress and never before questioned, may be treated as a gloss on executive power vested in the President. In other words, Presidents Washington, Adams, Jefferson, and Madison, through their actions, added a new gloss or supplement to the Constitution. Justice Frankfurter explained that because Congress approved of these long-standing practices, courts should hesitate before disturbing that settlement. Unfortunately for President Truman, however, Justice Frankfurter found that there was no systematic, unbroken executive practice of past presidents seizing private property. Therefore, he concluded, President Truman did not have the executive power to seize the steel mills. Justice Douglas wrote the second concurring opinion. It was based on the structure of the Constitution. The President has no power to raise revenues, he explained. That power is in the Congress by Article 1, Section 8 of the Constitution. The Fifth Amendment requires that the government must pay just compensation when it takes private property. Because the seizure of the steel mills was a taking, the government had to pay the steel mills just compensation. Therefore, Justice Douglas concluded, the branch of government that has the power to pay compensation for a seizure is the only one able to authorize a seizure or make a lawful one that the President has effected. In other words, the seizure was a taking, and the Constitution entrusted this quintessentially legislative act to the Congress. And Congress had not granted the authority for the President to seize or take the mills. Therefore, Justice Douglas found that the taking was unconstitutional. Justice Jackson wrote the third and most influential concurring opinion. Justice Jackson had previously served as President Roosevelt's Attorney General. He admitted that there is a poverty of really useful and unambiguous authority applicable to concrete problems of executive power. As a result, he reasoned, isolated clauses of the Constitution cannot resolve most problems. Instead, Justice Jackson explained, there are three zones of presidential authority. In the first zone, the President can always rely on all constitutional authority that he possesses in his own right pursuant to Article 2. And he can also rely on the power he has been given by the express or implied authorization of Congress pursuant to its Article 1 lawmaking power. Because the President possesses power from both sources, in his first zone, he has maximum authority. Therefore, in the first zone, the court should apply the strongest presumption of constitutionality to the executive action. Study guide: what is a presumption of constitutionality? My colleague Randy Barnett has written that the opposite of the presumption of constitutionality is the presumption of liberty. Although Youngstown is not a traditional rights case based on the Due Process Clause, does the constitutional separation of powers protect individual liberty? If so, whose liberty? We'll come back to the second category in a moment. In the third zone, the President can rely only on his own constitutional authority. But that's it. Congress has not delegated any legislative authority. Therefore, the president's power is at its lowest ebb. The judiciary must scrutinize all executive actions in this third zone with caution. What about a case where the scope of the congressional delegation of authority is unknown? In this second category, the president's authority is in a zone of twilight. That is when the sky is not quite night, but not quite day. How should courts review executive actions taken in the zone of twilight? Justice Jackson explained, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables, rather than on abstract theories of law. Applying this framework, Justice Jackson found that President Truman's executive order fell within the third zone. Congress did not authorize the president to seize the steel mills, and the president lacked the inherent Article II authority to seize the mills. In this third zone, Justice Jackson applied a form of strict scrutiny. That is, he scrutinized the executive order with great caution to identify any flaws or defects. After this rigorous review, Justice Jackson found that the executive order was unconstitutional. Although it was only a concurring opinion, Justice Jackson's three-zone approach would become the Supreme Court's definitive approach to analyzing separation of powers cases. Chief Justice Vinson wrote the dissent. He was joined by Justices Reed and Minson. The dissent looked at history very differently than did Justice Frankfurter. Chief Justice Vinson explained that Presidents Washington, Jefferson, Lincoln, Roosevelt, and others dealt with national emergencies by acting promptly and resolutely to enforce legislative programs, even without explicit statutory authorization. Study guide. Do the president's authorities expand during an emergency? Do those powers contract after the emergency concludes? Therefore, Chief Justice Vinson concluded President Truman could faithfully execute the laws by acting in an emergency to maintain the status quo, thereby preventing collapse of the legislative programs until Congress could act. Within minutes of the Supreme Court's ruling against him, President Truman ordered Secretary Sawyer to return the steel mill to the owners. Study guide. What would have happened if President Truman ignored the Supreme Court's order? The labor strike would last 50 days as the Korean War continued. Contrary to the government's concerns, there was no apparent disruption to the military steel supply lines.